you've ever felt like DataQs was inconsistent, opaque, or just stacked against carriers, you're definitely not alone. It's a complaint we've been hearing since the advent of DataQs, and one that's gotten louder since CSA went live in 2010. The Federal Motor Carrier Safety Administration says it's now trying to fix that with a process that's supposed to be fair, more timely, and more transparent, including more accountability for states and a new 3-level appeal structure that includes independent review of contested violations, all set to launch this September. But the real question was whether these changes are going to help carriers get better outcomes, or just create a more formal path to the same frustrations. That's what we're going to dig into today with special guest and partner at the Scopelitis law firm, Sue Lawless. Sue came to the firm after 15 years at FMCSA, ultimately serving as their executive director and chief safety officer. So, without further ado, let's get to it. Okay, and welcome back to the Triple T podcast. I am Sean Garney. I'm here with my co-host Steve Keppler, our TrueNorth representative today, good friend John Biblis, JB for short. We're coming at you to dig into some big changes recently announced by FMCSA. It's an effort for them to create a DataQs system that is perceived to be fair, more timely, and more transparent, addressing many of the complaints we lobbed at FMCSA as an industry over the years here. So happy that joining us today, our expert in residence is Sue Lawless. She's a partner at the Scopelitis law firm, but most recently held key high-level positions with FMCSA. So with that, I'll say thank you, everybody. Welcome, Sue. Maybe you can take a minute and tell the folks about yourself.
Sure, Sean, thanks. So my name is Sue Lawless, as Sean said, and I most recently was the Chief Safety Officer at the Federal Motor Carrier Safety Administration. I was also at the agency at the beginning of the DataQs process when it first came out and came into being. I have a lot of historical knowledge of how it came to be and look forward to talking about it and engaging on is it better or is it the same old, same old?
We're so excited to have you because you were there when the sausage was being made. So,
but I didn't make the sausage. I'm just using it.
Wasn't your recipe?
No, it was not. There were a few things I would have asked for in that recipe that were not added to it.
Yeah, deflect. All right.
Very good. Very good.
Well, Sue, thanks again for joining us. Maybe just kind of level set for everybody and our listeners. Maybe start a little bit, kind of a basic, what DataQs is, what does it do, and why should carriers use it?
Yeah, so DataQs is the system that the Federal Motor Carrier Safety Administration has where you get a chance to correct your data that's being gathered during roadside inspections. So the DataQs system is used to challenge both inspection results, but it's also used in the agency's crash preventability determination program. And I think today we should focus on just the challenges to the inspection process because that's what the most recent notice was about. When the SMS system, the safety management, safety measurement, it's gone back and forth over the years, was first stood up, that was a change for FMCSA. Prior to that time, the agency decided who it was going to see for inspections by generating a list, a priority list that wasn't shared publicly, that didn't include an analysis of roadside data, and that's how they generated the list of the highest risk carriers. And then there came a point where the agency said around 2010, we gather 3.5 million inspections a year, and that's so much data that we're just ignoring and not using. So there was an effort when Anfero was there to come up with a better way to gauge whether or not a company should be subject to an investigation, because as everybody knows, there's just way more motor carriers, way more regulated entities than there are investigators and inspectors at the Federal Motor Carrier Safety Administration. And when it was first stood up, one of the things that was a promise that was made was that because they are now changing how they're using your data, that there would be an opportunity to correct your data. And anyone who's been around long enough knows they didn't exactly do that at first. So there was no DataQs process at first. And then they implemented DataQs, whatever you think about it, in its current form, present form. And now they're making changes to it, which are welcome changes, but I'm not sure they go far enough.
Yeah, it's true that carriers cared a lot less about their roadside data until their business partners and FMCSA started making decisions about them based on that data. So,
and it being public.
Yeah, and it's public.
Yeah, and it being public for sure. So can you give us, so we know what DataQs is. Generally, it's a system that allows us to try to correct what we perceive at least as erroneous data. At a high level, can you tell us how that system functions today?
So today, remember, there's kind of this dichotomy between whether or not the data that is collected during a roadside inspection is considered to be federal data or state data. So a decision was made a long, long time ago that in fact the inspections that are conducted roadside are considered state data. So in the DataQs process today, when you challenge an inspection, and let's just put them all in a broad lump category because there's different types of challenges that have different problems with them. But if you say, hey, you know what, that inspector didn't cite me for the correct violation, I want to say that that is incorrect, you would file a challenge in the DataQs system through the portal account, and you would have to present evidence to show why that inspection is incorrect. Now, the burden is on you to show that that inspector is wrong. And under the current process, that request gets funneled back to the state for the state to decide. So the lead mix-up agency in most states, that request goes back to them. It may very well go back to the inspector who did that inspection, although that is discouraged and has been discouraged. But it could go back to that inspector or at least somebody in the chain of command. You upload whatever documents you might have to say that that inspection is wrong, and then somebody makes a decision on it. They might ask you for additional documentation. You might submit that through the portal, and they respond to it. They either deny it or they say, no, you were 100% correct. That's right. We will either remove it or we will note that it has been corrected, depending upon the data correction that you've asked for.
So, I mean, one of the complaints we've heard from industry for years on this is the fact that things are different from state to state, right? Yeah. And where you sat in FMCSA, kind of where this variability across the country, where did you see where the major breakdowns were? Like, was it on process? Was it on outcomes? What was your perspective where you sat?
So we really started focusing on this during the first Trump administration. That was a key priority for them when they came in, was this notion that there was this tremendous disparity across the country in terms of how inspections were conducted, how DataQs were processed. And I think the problem is that FMCSA has very limited authority in terms of telling a state what to do. So historically, FMCSA really took a hands-off approach. There were sometimes one-off instances where you could kind of appeal to the better nature of FMCSA and say, hey, you know what? This state is interpreting this regulation incorrectly. Would you do me a solid and work with the state and get them on board with this interpretation? But there was no consistency across the board from state to state in terms of how they're handled. Some states have a very good, process where there is what I would consider to be an impartial panel that hears your DataQs appeal, but most states don't. And when you look at the variability in states and the funding that states have and the personnel that states have, in my opinion, they're just not set up. This is just another thing we're asking them to do, and they didn't get any more money for it, but it's just another work piece and workflow that they have to figure out how to do. So it's a bunch of different things, but at the end of the day, I think the problem is FMCSA does not have the ability to say, hey, you need to do this correctly or there will be consequences. So there are no consequences.
Okay, so, first I'll say, here's how I experience DataQs, like on behalf of motor carriers, right? And I know JB files these, I know Steve has filed these. We create an argument that supports our case. We send it through the system to the state. It's reviewed by a DataQ analyst who typically provides some response that says, I talked to the issuing officer and you're wrong. thanks, come again.
Yep.
And then you try to reopen it, but you need to bring new evidence to try to reopen it. And, perhaps we prevail or perhaps we don't. I've experienced this committee, and often they don't tell you what your optional next steps are. And I've not had a lot of interaction with how the committee works. But would you say, first of all, would you say that that's a fair kind of assessment of the state of play across most states?
That's a very fair assessment across the majority of states. It is a very inadequate process, and the communications during the process are very obtuse. Like you get back, your example of I talked to the officer and he said it's a violation. And you're like, okay,
Thanks for that. That's really helpful.
Thanks. Yeah. Yes.
So I think that that brings up a good question. Obviously we're going to talk about this in a minute, the changes that are being proposed, but do you think these changes are being driven by the industry's frustration on this inconsistency and this difficulty, or more on the agency side finally saying, enough is enough, we need to figure out this better?
So I would love to say it's a combination, but I think it is being driven mostly by the industry. But there's a second player that has come into the room that is driving them to try and make this better, and that is the fraud that is prevalent in other systems has started to infiltrate the DataQs system. So now they have a concern about okay, so now it's a, you guys have been around a long time. You know how FMCSA used to develop systems. It's a siloed system, right?
Yeah.
It's all on its own. It has some security vulnerabilities. And so they're starting to see from a fraud perspective that they need to get a better handle on what's being challenged. This was something that they started 8 years ago, right? And then it got picked back up during the second Trump administration. And that's really been the driver. Like they've been working on it, but it has been intermittent. I would call it an intermittent interest in fixing DataQs.
It's pretty wild how the fraud has, sorry, Steve, how the fraud has entered that too. I mean, we saw a whole bunch of cases, like a year ago, where people were trying to steal clean inspections from client carriers of ours and put it onto their other records. So another vulnerable system. This could be just a great time to update it altogether, maybe. Sorry.
I think they are. I definitely think they are. When I was at CVSA, Steve, I don't know if you were at this meeting, but there was somebody who said that they are getting DataQs on inspections as soon as the inspection occurs, and they're dealing with roughly 2,500 inspections a week that are being challenged through the DataQs process, which seems inconceivable to me. So there is some level of strangeness going on within the system.
Yeah, they're flooding
the upside down.
Yeah, for sure.
Yeah, but it makes it harder if you have a serious challenge. What problem that presents for the industry is it makes it harder if you have a legitimate challenge to a DataQs to get behind that noise and say, no, look, I'm a real person, I'm really filing this. So it's problematic that they now have to fix that.
And that's a good opportunity to insert a pro tip for our listeners. Pro tip.
Sound attack. Pro tip from Steve.
Don't take the spaghetti on the wall approach and challenge everything. Make sure, because number one, you're probably going to lose a bunch of them, but number two, you don't want to waste the enforcement agency's time in dealing with stuff that's not worthwhile. So
we have been given that advice for as long as DataQ's been around, and I know it still happens. Here's what I think is the bigger takeaway from that advice. There are only so many DataQs analysts in each of these states, and the more crap you throw at them, the more they get used to your name. They feel like they know your email. And then they're like, oh boy, here comes Keppler again, arguing about this, that, or the other thing. He's out of here.
It's not me. Not me.
No, that's true. You guys are absolutely spot on. Also, the data analyst manual is online. Like if you're going to take the time to file a DataQs, make sure that you know what the analysts are looking for, and then model your DataQ to what the analyst is going to be looking for. And reputation, people talk. So people do talk. Yeah. If you get a reputation as a bad actor, it's bad for you.
Absolutely.
Oh, man. Well, from one bad actor to another, just kidding. Maybe we'll move into the changes now.
Yeah.
So maybe you can talk a little bit about the changes, and I'm interested too, like, I don't want to forget that FMCSA proposed a whole different change to DataQs before this one was finalized about interpretations. And so, and I saw that you had an interesting LinkedIn post about sort of what the agency role could be. So I'd like to just kind of keep that in scope too as we talk about what some of the proposed changes are.
Yeah, do you want to talk about what I think is good or what I think is bad first? Do you want the good news or the bad news?
Maybe talk about what it is first, then we can talk about good or bad.
Yeah, that might be a logical approach, Steve. So the revised DataQs process is really just a Federal Register notice with what I would call a high concept proposal for what DataQs will look like in the future. And so it goes through the proposal that had been initiated 4 years ago, guys. It's a long time ago.
Yeah.
And makes some pretty significant deviations from the original proposal and comes out with a slightly different process, but nothing earth shattering. So some of the significant changes is that it, first of all, brings the DataQs process into the MixEP funding portfolio. And so it ties your performance on how you are handling DataQs to your MixEP money, much like other things that you do. So now states are going to be required to set forth their DataQs proposal to FMCSA, and that's actually happening at the workshop, which I think is next week, Steve, maybe the week after. So all the states are supposed to come in and they're supposed to say, okay, FMCSA, here's how we plan to give a full and fair process for our DataQs. It sets out a 3-tier criteria for your challenges. So the first level of review, when you say, I didn't do it, you come in and that challenge could go back to that same inspector. But if that inspector is going to deny you, there has to be somebody else looking at that review. So he can't decide on his own that you didn't meet your burden of proof. The second level, at the petition for reconsideration level.
Who's that person first? Who's that person who has to corroborate or agree?
Not
we don't know.
We don't know.
It could be the analyst. It could be an administrator of DataQs.
Someone in the MixEP agency.
Yeah, someone in the MixEP agency, but it doesn't limit it to that, Steve. Like it could just be some schmo that walks in off the street. And
could be
like,
JB for all we know.
Yeah, it could be you, Sean.
We need a motor carrier representative on that board.
Yeah, that's funny you say that because somebody told me that they were in a state where they had a panel that included a motor carrier, and they said, and this is something they told me, I don't know if it's true, they said the motor carrier is always harder on the violation than everybody else.
Yeah, I've heard that from a number of states that have that panel approach.
Yeah, yeah. So
what is it with that? That's crazy. Know. Like my son's high school soccer team, sometimes his mom is the main ref, and she calls it even harder. Because
she wants to look fair. Because she wants to look fair.
She's over fair.
Right.
That's what I think. Give us some calls here.
Right. Yeah. Overcompensated. So let's say you're denied in the first round and you're like, that's wrong. I'm going to challenge it. So then you file a petition for reconsideration, and that goes to somebody who's not within the chain of command of that officer, but could very well be somebody that's still working at the MixEP agency. So it's not specific. It's not telling the agency how they have to set it up. It's just giving them some options. But remember, here's the key part from an appellate process perspective. Whatever evidence you put in the first place, you're kind of stuck with when you file that petition for reconsideration. So if you file a crappy first petition for review, when you get to the second level of review, Generally speaking, you're not going to be able to add new evidence. Like, aha, I finally found this sworn statement that was given to me. They're not going to allow you to introduce new evidence. So it's kind of an on the record petition for reconsideration. And they're just looking to see, did they make the right choice, the right decision in the first place? Okay, so let's say you get to that point and you still believe that they are incorrect, flat out wrong. Well, then there has to be this last, what they're calling the last layer of appellate process, some kind of appellate process, where it is supposed to be an independent body that has the appearance of fairness, but they don't specify who that has to be. It doesn't say it has to be 10 people, one person. It doesn't say it has to be a judge, a lawyer, a motor carrier. It doesn't say who it has to be. When you get to that appeals level, that appellate decision maker could ask you for additional evidence if they chose, but most likely they're going to rely on whatever evidence you had in phase 1, in phase 2, and then in phase 3. Once you get to that last layer of appeal, you're kind of done, unless the state allows you to start over again, which is, I can see that being very unlikely that you would succeed. If you don't succeed by the third try, it is very unlikely, unless something has just gone very off the rails, that you're going to succeed.
And you got to believe in it real hard, because that's a lot of resources.
Yeah.
For
Now
here's
here's what's missing. So that's the process. The key is that there's no federal, what you heard me say is there's really no federal role in the appellate process itself. You can't go to FMCSA and say, hey, FMCSA, I believe state Nebraska is interpreting, not to pick on Nebraska, Nebraska's lovely, but they're interpreting this regulation incorrectly. And I want a ruling or a guidance from FMCSA on what this regulation means. There's no role for FMCSA in doing that in this process. And so you're really kind of stuck with whatever the state does. And FMCSA's only, if you think about what FMCSA looks at now with the MICSAP funding memos and what they're looking for in your safety plan, this is just going to become another widget, in my opinion. What they're going to be looking for. So the one thing I didn't talk about that this guidance, it's not a rule, that this guidance does is it sets timeframes for how long they have to make a decision on your petition.
Pretty aggressive timeframes.
Yeah, pretty aggressive, very unlikely to be met. But that's what they're going to be measuring.
Hey, that's a question for later.
Yeah, whatever. It's just not going to happen. The majority of time, it's not going to happen. And then there is no real anything that FMCSA has. They don't have any skin in the game, right? They're going to theoretically judge you, much like they judge the timeliness of you uploading your inspections. They're going to judge, did you get enough widgets done within the time period? But they're not going to go back, because they just, in fairness to them, they do not have the people to go back and do a real audit of these processes, to do like, hey, let's pick like 4 states and let's see if we would agree with how this issue came out. They don't have that kind of time. They don't have that kind of manpower.
Yeah.
Go ahead.
Yeah, no, you're right. I think it's going to be, that's to me one of the downsides of this approach. The fact that they're requiring the plans, and they're going to be measuring and publicly, it's going to be incumbent upon the industry to watch the states, right, and call them out to account if they're not following their plan, if they're not meeting their timelines or timeliness. And so, I recall back years ago when I was at CBSA, when they introduced the state safety data quality measures, put them out on the web, and the states went apoplectic. They did not like that at all. So I think it's going to be incumbent upon us to help police this and call out states that aren't fulfilling their obligations.
Yeah, and it would be helpful if FMCSA was just a little bit more transparent about information on, how many DataQs are there? Where are the DataQs?
Please.
What's your percentage?
So hard to get that data.
Right. It is not available. I double checked. I thought, I was like, I can't believe that this isn't someplace, and it's not. And then I asked FMCSA like once a year. I asked Scott whether there was a plan in the works to do it, and I'm actually having lunch with someone from FMCSA in the near future in IT to see whether that's a possibility that could be built into the system, because it makes no sense. It's just a black box of how they are doing.
Well, and that's
So
to Sean's point. We've been asking for that for years, and it provides a couple things. Number one, I think it will certainly help under, understand what the states are doing, but also it will help the industry. If these are the types of things that are not failing, so you may not want to challenge these, right? So it makes
Hmm.
oh yeah,
it can reinforce and make the total system more efficient.
I mean
It
they
would.
do it with the preventability program,
Yep.
Yeah,
and I find
Yep.
that data very helpful.
yep,
Yep.
Truthfully,
It would also be a way to issue spot. So if you've got 10 carriers that are disputing the same violation as being cited the same way, so it'd be helpful to CVSA for them to know that there's an issue, that it's not just one person that's seeing it, that there's
yeah,
10
for
people that
training.
are seeing
yeah,
it.
and I
Yeah.
think that brings up kind of because you had talked about that there's no FMCSA role in here. Of course, the previous proposal when they proposed to improve DataQs, that was their main focus. Is like, hey, we at FMCSA, we're going to play referee in some cases, and not all cases, but in some cases. And I thought, oh, that was an interesting idea, and we could really benefit from some of that interpretation. But I also wanted them to do this other thing where we improved our transparency and the beat the he said she said argument. Um, why didn't they do both? Why didn't they finish? Why do you think they didn't finish the FMCSA interpretive portion of it?
Well, I mean, there's a lot of different reasons. You had a change in administration. You had a change in viewpoint. You had just a people issue. You had the number of people that were available to do this, and so if you've ever handled an enforcement case with FMCSA, they've got a tiny population of what they call adjudications attorneys who are kind of separated and apart from everyone. So there was a lot of debate about who would handle that role within FMCSA. And I think there was a lot of disagreement about whether um, the adjudications attorneys would be the people that would be most qualified to handle. Let's take just a very technical mechanical violation, right? Like, should that be somebody like that, or are you better off having the state agency that actually handled these on a more routine basis? But at the end of the day, I think it's a numbers problem. Like, there just aren't enough people, hours in the day. And there was also, from a process perspective, like, where would you insert that? I did talk to Scott Valentine, who's been handling this for a really long time, um, during the CVSA meeting. And I think this is what I would call this Federal Register notice, is kind of when I said it was a concept paper, I think it is a concept paper. I don't think this is the final answer. I think they're open to improvements in the process. And I think if you can offer them a way where, especially on those areas where an interpretation of a federal regulation it becomes, or even let's say it's an interpretation of an out of service, and should that go to CVSA, like, just a process so that you could get consistency. I don't think they're opposed to it. I think they're working through how would that work for them, who's going to do that for them. It's kind of funny. I'm surprised they're bringing AI into a lot of their work to try and kind of work around the lack of people with tools that will make it easier. And it does seem like this process is what I would call AI amenable, not AI final. Like, you don't want AI making a final decision where you can't tell how that was rendered, but certainly,
Human in the loop kind of
bucketing
situation.
things together, seeing similar issues. But I think they're so far from that because this system is so old now. I think they just can't do it.
Well, and I think you're right, Sue. It's a resource issue first and foremost. I do think, though, I think part of it is, well, this is state data, let the state own it. But I do think there's an important federal role, personally.
Yeah.
And I, from my perspective, I would still, because I've done this with DataQs in the past when states didn't properly, in my view, for working for a client, I appealed it to the division administrator.
Mm-hmm.
And so, to me, for our listeners, if you're a carrier, make sure you have a good relationship with your FMCSA people in your state, because I got in one case, I got the DA to overturn a decision, but the state had made. So I think it's important to, in the event you've got some really, you feel you're really on sound ground, and particularly if it's a regulatory or a guidance question, I would go ahead and appeal it to your state DA. You never know what they can do. So.
Hey, Steve, thanks for the pivot there. I just want to be conscious of our motor carrier listeners for a second. And we've talked a lot about states and FMCSA and kind of the process and the revisions. But what do you see as some key takeaways for the motor carrier that's doing these data queues? We mentioned, be discerning on which ones you're going to data queue, right? Don't throw everything on the wall. And then you talked a little bit about making a strong argument on your first pass because you don't get an opportunity to necessarily add to it. But what else is there that the motor carrier needs to keep in mind to help them up their chance at success?
Yeah, so it is very helpful. Treat it like a real legal proceeding, like with the thoughtfulness that you would do if you had to go into court. So make sure that it's very easy because it's an all online process. And so you're like, oh, my driver didn't do it. Bam, I'm done. Here's, that's it.
I've seen a few of those.
But make your legal argument. If you have a piece of guidance that you're relying on, submit the guidance with your data queue. If you have a statement that you can get from someone, from a dispatcher, if it's like a logs issue and you can get a statement, an ELD issue, get a statement. So present evidence as if you were in court, like treat it like that, because they're not going to change it. If all you have is the inspection and then someone kind of saying, well, I don't believe that was a violation, they're not going to do the work to figure out why it's not a violation. So you have to do the work for them. Like I always try when I approach like representing someone in court, I always approach it as I'm trying to make the judge's job as easy as possible to rule in my favor, right? Like I don't want them to have to work. I want to give them the guidance. If there's, some other document that you need to submit that. Don't submit it, piecemeal to them, submit it all at the same time. And then, for instances where, and here's the pitch that I'll give to motor carriers. So you might think like, I don't need to pay as much attention as you guys seem to think I need to pay attention to my inspection data. Like I have great inspection data. Why should I pay attention to it? It's always good. Well, the reason you should pay attention to it is because people now know that you have good inspection data. So you are becoming a target for people trying to steal your inspections and trying to change your inspection data. So whether you have good data or bad data, if you have good data, people are going to try and take that data. And if you have inspections, if you don't get a lot of inspections, it is very easy to go from being not of much interest to FMCSA to being very interesting to FMCSA with one or two bad inspections. So
things can change fast. That's
for
sure.
Yeah, for sure.
Well, so you just brought up another good point, Sue. Just one more, and then I'll.
Yep. No, please go
back. But so both Steve and Sean, and now Sue, y'all have mentioned people stealing data. Talk a little bit about that. What does a motor carrier need to look for, or how can they be aware that somebody's monkeying with their inspections?
So I'll go first, and just based upon what I have been told, not any firsthand experience in I guess there was one or two people when I was working at the agency who called us up and said, hey, we think somebody is stealing our inspection. So what I've heard is, you get the smaller companies, let's say the less reputable companies who have their drivers. There's what I call the lowbrow fraud. So they'll just copy a DOT number. And that's the number that they will put on an inspection. So suddenly you have an inspection that's attributed to you that's a bad inspection. That's one way. Another thing that the more sophisticated, what I would call scheme that I heard about at CVSA is they are filing a data queue. It appears to be on your behalf. They're trying to pretend that they are you, and they are saying, hey, this good inspection really belongs to me. It doesn't belong to this other carrier. So they're going in through their account and trying to grab your inspection. So I don't know how most carriers, you probably know, JB, how most carriers are tracking their inspections, but I would say I would want to be very careful that every single inspection is accounted for in my data, that both like missing inspections and then inspections that were there and then somehow disappear. Because the fraud that I was hearing about was so stealth that you may not notice, because let's say, and remember, data has a long tail, right? So that data is going to impact you for 2 years. So you might have forgotten about that, 100 inspections that you had a year ago, and then a company could come in and say, oh, by the way, those weren't that company's, they're mine. So those are the two kinds of fraud that I heard about when I was working for the agency, and then at the CVSA meeting.
Our clients have received emails from DataQs. So when there's a DataQ on a DataQ attempt, they get the update because it pertains to their business. So that's how they identified it. I don't know if that's always true. Like, for sure, monitoring all of your DataQs.
Well, and making sure your drivers turn in your inspections, right?
Yep.
Yes. Yep. For sure.
Yeah.
I think
because that's always important too. If one didn't get uploaded, you want to get that uploaded.
That's right.
Yeah.
Exactly right. JB, I think one other thing that I've found useful, back to your question, is if you're not a member of CVSA, you probably should consider it, because you can have access to their operations manual, all their operational policies,
Inspection bulletins.
Pro
tip: Steve Keppler.
That's right. So and use that if you find something. I mean, it's important you're familiar with those, because then you can use that as evidence if you're challenging a DataQ as well. So that's useful as well.
Well, and Sue brought up a point, speaking about manuals, the data analyst manual, just to understand what they're going through. That's something that I hadn't been on top of, but I will be now, and I'm sure it'll be helpful to
it's a little dated, but it's still helpful for sure.
Yeah.
I'm sure they'll update that right away, Sean.
Yes, I have been waiting for that update for years, but I will continue to wait. Sue, tell me, what is a valid reason? So the Federal Register notice talked about having a valid reason to challenge these things, and they really didn't answer what that means. So I'll just go ahead and ask you, what do you think a valid reason is? So for context, in order to go to the next level and to challenge, you need to have a valid reason why you're disagreeing with whomever made the previous decision. So tell us, Sue, in your infinite wisdom, what is a valid reason?
It's a made-up term. It's completely made up. It doesn't have any legal significance. Like, that's not used anyplace else in a real judicial process. So my feeling would be that a valid reason would be any reason that the person deciding your next level of review would think it is. But a better answer that would be more helpful would be, you have to have a reasonable basis to believe that the violation that was cited on your inspection is incorrect. So, for example, easiest example, it's an incorrect interpretation of a regulation. It is an incorrect application of the inspection policy that is put out. So you cited me for an out-of-service defect, but under the manual, that shouldn't have been an out-of-service defect. Things where you cited my driver for not using an ELD when the driver was clearly using paper logs, and so had the paper logs in their possession and noted that there had been a malfunction of the ELD. So reasonable basis is what's normally included in legal proceedings. Like, you have to have a reasonable basis to file a lawsuit. So valid doesn't, if you looked up valid and all the, Google it, you can probably figure it out. I'd be curious to see what AI says a valid reason is. It'd be like,
it's in the eyes of the beholder, right?
Well, that was my kind of smart alecky answer, which is very loosey-goosey on what a valid reason
kind of like English language proficiency, right?
No, it's sufficiency, Steve. I just was telling somebody about that the other day. They've now changed it to proficiency, But I went back because I kept thinking I was reading that rule incorrectly, but proficiency does not appear in that rule. And I was going to give a sewing example to distinguish between proficiency and sufficiency. And then I thought I better learn about some sports because nobody's going to understand my sewing reference. And then I talked to my husband and he was like, you better not try and make a sports reference. You'll just screw it up completely. But it's sufficient. Yeah, it's a made up term, but probably what they are trying to say is a reasonable basis. Like which is kind of like you can't just make stuff up. It can't just be your feelings that you got picked upon because you got an inspection and it has a violation. You've got to have some kind of credible legal argument or factual argument that what happened to you was wrong.
Yeah, and I think this is where, I'm hopeful that I think this will be helpful in the long run, but one of the biggest challenges we see on these today, and I don't know how much this is going to change it, is the whole he said, she said arguments. Right?
Yeah, it's not.
Yeah. I mean,
it's not.
Yeah.
Well,
see.
The other problem, and I'll just give my pitch for why the burden is on the wrong person here. And close your ears, Steve, because I know you were president of CVSA. But so if I get a ticket, or if your driver gets a ticket and they go to traffic court, the burden is on that officer to prove that a violation occurred. But if you get an inspection and you go through the DataQs process, suddenly that burden has shifted to you to show that the officer was wrong. And it seems like a difference possibly without a meaning, but it does meaning. It means that the officer goes in with the benefit of the doubt into a DataQs process. So basically, you're always kind of behind the curve trying to prove somebody is wrong instead of coming in and saying, okay, prove your case. Show me what evidence you had that my brakes were out of alignment. And I think what we are seeing is that I do think the inspectors are becoming more mindful of having to collect evidence. But there are still inspections that I see where I'm like, there's no evidence behind that. That's purely what that officer said he observed. They didn't take pictures of anything. So it is in my mind still an imperfect process if you are going to use that data to do bad things to me, right? And the argument has always been, well, nothing bad happens to you merely because we've identified you with a check mark or your basic is above the threshold, which now nobody can see, whatever. You can see it plenty if you pay for it. But I do think that the way that data is now being used is completely different than how it was being used 10 years ago, 15 years ago. 100%. And I would have argued that the burden should go the other way.
Well,
all right. So, go ahead, Steve.
No, you bring up a good point, and I know we're trying to wrap here shortly, but I think the one thing that they try to get at that, which I'm hopeful will provide some measure of improvement, is particularly when there's closed, no action taken. They have to document the reason why.
It. Yeah.
Right, and so they're hopefully, if I'm a carrier perspective, be watchful of that. If you get turned back, make sure that the officer tells you why and provides explanation. And that if that's not good enough, well, then that gives you an opportunity to move it to the next level review.
This is something I was thinking about too, because you know what? I never get a closed, no data correction made DataQs. It doesn't tell me something about why they decided that. And often it's, like I said before, like, oh, I talked to the officer and he said this is what he said and this is how we saw it and whatever else. And so maybe it remains to be seen if that is still like meets those sort of lofty transparency goals, to give you that reason. I want to come back. I did Google what a valid reason is, and I think it's a little instructive, actually.
It's a rabbit hole.
ChatGPT said it's not a fixed term. It's dependent entirely on context. The general meaning is something that is factually too relevant to the issue at hand and considered reasonable by a neutral third party. So that is our valid reason. Can I just brass tacks this thing, Sue?
Yeah, go for it.
Are motor carriers going to win more of these things or not?
No, but it's going to take them longer to get to know.
Great.
All for it.
That's kind of the sense that I got. I mean, I'm for all of these goals, like transparency is always good. And I have felt the frustration in the process. But I kind of get the sense that like ultimately, you know, reasonable minds are going to disagree, and our data is going to be where it is. You know, unless you have a compelling reason, like some of the examples that you provided, where, well, I think you've misinterpreted this. You know, I have always felt what, like with DataQs, I was making two arguments. One's like that factual argument, and the other one's about like me telling the officer that they did the right thing, but that we're just a little bit different, and you did a great job, and oh, maybe you can write us for this instead of that. So there was always that sort of interpersonal thing as well.
So maybe the motor carrier doesn't win more with the revision of the process, but what the motor carrier needs to do is get smarter about how they approach it, right? I mean, that's what you said, to make a legal, treat it like a legal process, make a strong legal argument, provide supporting documents and proof of your argument, right? And then maybe the process treats you a little fairer.
Yeah, and I think you keep in mind what Steve said earlier, and that's a really important point, is to maintain relationships with your division administrators where you are located, because they don't say squat in this notice about, oh, the division administrator is completely out of the process. Now, the state might be a little reluctant to go to the division administrator, but the division administrators that I know, they're always willing to engage and be helpful and try and work things out with the state. So keep that in mind for those tough ones where you're just not getting anywhere with the state and you think you have a righteous cause. Don't be afraid to reach out to division administrator. You're not going to get in trouble. They're going to be there to help you 9 times out of 10.
Yeah, agreed. And the other thing I think sometimes gets lost, a lot of folks in states are different about this. Sue, you and I have had this conversation. If the inspection report, if the inspector has inspector notes that they've documented on the inspection, request those notes.
Yep.
They won't always provide it to you. So but ask that question.
So there are super secret notes that are being taken, depending on what state you're in. And in some states, you're going to have to go through
conspiracy notes.
Yes, we'll have to have another podcast on this. But you might have to go through like whatever their version of FOIA is to get those notes. But in other states, they might give them to you. But you should always ask, are there any notes, photographs, videos that you can send
Double
me
secret
of
notes,
this inspection?
super secret notes.
Okay, next podcast. Okay.
Well, that's great advice. I'm still trying to get carriers to use the original copy of the inspection versus something they pull off of, out of safer, because just the officer's notes on that inspection can really help you out.
Yeah.
A lot of motor carriers go to that extent. So now I got to look into the secret and the double secret notes.
There's so many notes out
there.
So many notes, so much evidence you aren't seeing, so many things you don't know about.
You got to learn the secret handshake, JB.
Yeah, for sure. Awesome. Well, I think we're kind of sliding into the end here. I think we did a pretty good job of covering this. We'll have to bring the gang back together after the changes are made. Now, before we go, this is probably important. States have 150 days to rejigger their process, like 150 days. It took states like 20 years to integrate with the medical registry. Are we going to get this done in 150 days? Can I start September 15th data queuing? And when I can, is it retrospective or prospective?
Yeah, you had posed that question to me. It doesn't really say in the notice whether it talks about, the period of time. So, how many years back you can go to file an inspection. So I don't know the answer to that question in terms of whether it is truly you're going to be able to go back and use the new process. I think you are. I think the answer is you're going to be able to use the new process for anything that's within the window. But I don't know. I don't think every state is going to get it done. They're doing too many other things. They're still trying to figure out non-domicile CDLs, ELPs. Like there's just so much that they are trying to, and they still haven't figured out the medical integration.
Yeah.
So
bet the over. That's what Sue says. Pro tip: bet the over.
But I think
better sound effects than that.
That's a true story. That's for next podcast.
Yeah, I think you're right. I didn't see anything in there that's saying only prospective. It was silent on it. So I take that to believe, and you can challenge 3 years on inspections and 5 on crashes.
Yeah.
Under the new process. So.
But stay tuned, because they did say that they're going to publish whatever the state's process is on the DataQs website. And I was like, really? Huh.
Yeah, that'll be interesting.
Yeah.
It will. Yeah.
Oh, cool. All right. Well, thank you, Sue, for your time on this issue. It's been kind of exciting and typically winding road. Glad we made it to the end, or close to the end anyway. So
I was going to make a smart comment how you need to get out more, Sean, but it's okay. You're like, DataQs is exciting.
Oh man. Well, I am mostly a shut-in here in South Dakota. The wind is blowing too hard.
I was going to say, what is it, like 30 below still? 30 below.
Sue, I try hard. He's a tough one.
I have to live vicariously.
Great information. Thank you for being here. We appreciate it.
Thank you for having me, you guys. It's been fun.
All right.
Thanks for listening to this episode of True North Truck Thought. If you enjoyed the topic today and want to tune in for future conversations here on the Triple T Pod, make sure to follow us. Also, please don't hesitate to let us know which topics you want us to cover in future episodes. Drop us a line in the comments section or send us an email to transportationnews@TrueNorthCompanies.com. Thanks and have a safe day.